Hi everyone, my name is Richard Lloyd and I'm IAM's North America editor. It gives me great pleasure to welcome you to today's webinar covering some of the seismic changes that have taken place with the Patents Trial and Appeal Board in the last few months. I think it's fair to say that in the 6 years of the PTAB, the new post-issuance procedures brought about by the American Invents Act have had a profound effect on the US patent market and patent litigation in particular. While the new procedures have attracted plenty of critics and supporters, they have also been subject to some change, most notably thanks to recent decisions from the Supreme Court and a proposed rule change from the USPTO. Today's webinar will look at how the PTAB has impacted the patent landscape and how some of the recent changes look set to alter the equation for petitioners and patent owners. Joining me to dive into the weeds are Todd Baker.
Thanks, Richard. Good morning to our American listeners and good afternoon to our European participants. This is Todd Baker with the Oblon firm, and I am pleased to have a brief opportunity today to share with you my views on the evolution of inter-partes matters at the USPTO over the last 6 years. When I'm finished with my discussion, Erica Arner will discuss the impact of oil estates and SAS on PTAB strategy. Brent Babcock will bat third and discuss the USPTO's proposed rule changes to replace BRI in favor of the Phillips claim construction standard for post-grant trials at the USPTO. Next slide, please. With the SAS decision in hand and the proposed rule changes to the claim standard looming, we have seen inter-partes matters at the USPTO evolve from a prosecution-centric practice to an almost pure litigation model. From a 10,000-foot perspective, we have gone from a system pre-AIA where robust amendments were allowed in inter-partes re-exam to a hybrid approach in inter-partes review where a restricted amendment practice has been allowed, but where the PTO is still applying the BRI claim interpretation standard. Today, a highly litigation-centric approach, due in significant part to SAS and the new proposed rules package, appears likely. With regard to amendment practice, currently, amendments are rarely filed and the jury is still out whether aqua products will increase their usage. If the claim interpretation standard is changed, there's also a time to see how practitioners will change their approach in light of Phillips being potentially applied to new proposed claims. Next slide, please. As I am sure many of you recall, pre-AIA, the USPTO employed an examination model in inter-partes re-exam, which enabled a robust amendment practice wherein patent owners had an unrestricted ability to propose new claims of narrower or clarified claim scope. Intervening rights were in play then, like now. However, patent owners still, in many cases, availed themselves to amendment practice in order to maintain validity and/or to strengthen infringement positions. Due to the robust amendment practice available to patent owners at that time, protective orders, including prosecution bars, were prevalent in order to protect proprietary information from post-grant counsel and experts working on an inter-partes re-exam. At that time, post-grant specialists handled re-exams and litigators handled the concurrent litigation. There was very little cross-pollination between the two types of matters. If the new proposed rulemaking is implemented, then IPRs will continue to be implemented using a motions model, and only a reasonable number of proposed substitute claims will be allowable for presentation. However, significantly, a Phillips-type claim interpretation will be applied to both challenged claims and proposed substitute claims. Due to the restricted amendment practice, however, prosecution bars for counsel will remain uncommon. Thus, we will continue to see litigators handling both litigations in district courts, as well as having a significant impact on IPRs at the USPTO. Next slide, please. In response to the effectiveness of IPR challenges since the fall of 2012, a need for smart prosecution strategies has developed. AIA has ushered in a need for stronger, more durable patents equipped to withstand patentability challenges at the PTAB. It has become imperative to develop a clear and comprehensive record during prosecution. Importantly, practitioners should be wary of patent owner estoppel if a portfolio case is an IPR. And, absent a pending continuation application and prior to asserting a patent or pursuing licensing revenue, practitioners should consider leveraging ex parte re-exam and/or reissue to reinforce a patent portfolio's wherewithal to survive IPR. Next slide, please. So one big question I've been asking myself, will there ever be a change in this trend? Will there be a return of the quid pro quo at the PTAB? That is, will patent owners ever again, in an inter-parties proceeding, have access to robust amendment opportunities in exchange for application of the BRI? I think today the answer appears that it's doubtful that this will occur. Thanks to oil states, IPRs are here to stay, and consistent with the Congress's intent and in light of SAS, there will be an increased likelihood of district court stays. Maybe not an intended consequence of AIA and SAS, however, we will likely see an increased use of ITC since there, in practice, stays are unavailable. Thanks for your time. I look forward to a deeper discussion on SAS and oil states and the proposed claim construction rules after we have a deeper dive on the mechanics of those events from Erica and Brent. Thank you. Erica, I think the stage is yours.
Hello, Todd. It's Brent Babcock at Knobbe. I think actually the next section is mine, and Erica from Finnegan will handle the last section on BRI versus Phillips. And good morning to those in the States. Good afternoon to those of you in Europe. Thanks for joining the conference. I think it's wise that IAM decided to have this conference about a month after the oil states and SAS decisions. I think that gives us an opportunity now to know a lot more about the impact of those cases than we knew initially. There were quite a few questions that those cases posed, particularly the SAS case, and now we have quite a few more answers. You'll see first we'll discuss oil states, a fairly straightforward discussion, so I won't spend a lot of time here. I think most people know that it was a 7-2 affirmance. Justice Thomas wrote the majority opinion. There were two principal attacks that were made against the IPR proceedings. One was an Article 3 of the Constitution separation of powers argument and whether or not an Article 3 tribunal, namely the PTAB, an Article 1 tribunal, namely the PTAB, had the power to take a property right or a quasi-public or private property right from an individual or an organization. The Supreme Court said yes, that an Article 1 administrative agency had that power, and it was not limited to Article 3 judges and juries. Similarly, with regards to the 7th Amendment challenge, a right to a jury trial, Justice Thomas wrote that the PTAB process did not violate the 7th Amendment right to a jury trial. Now, noticeably in the opinion, Justice Thomas did leave open a couple of possible future challenges for the IPR proceedings. One is a due process challenge potentially, or a takings challenge. So while we believe that IPRs are alive and well and will continue on to the future, the door is not completely shut for challenges. And in fact, I've heard that there are parties mounting challenges to IPR proceedings under the due process and takings provisions, particularly parties who obtained patents before the AIA was implemented. So AIA came into effect in 2012 and 2013, depending upon the provisions. And so patents that were issued prior to that potentially may have an argument that the AIA challenge is unconstitutional, something that they had not bargained for when obtaining a patent. But for the time being, IPR is alive and well, along with PGRs and CBMs. And given that so many litigation cases now involve IPRs and PGRs, they will continue to remain an important consideration for patent litigants going forward. Next slide. So the big discussion the last month has been over the SAS case, and the first issue was whether or not the board was going to change its implementation of institution decisions based upon SAS, and if so, how are they going to do it? SAS requires that the board issue a final written decision on all challenged claims. So the petition challenges 10 claims, potentially on 5 grounds. The decision in SAS says that you have to address all 10 claims. The PTAB has historically used its discretion to institute only partially on certain claims, say only 5 claims or 7 claims, and to also institute only on certain grounds, finding some grounds either the burden wasn't met or potentially that the grounds were redundant with other grounds. But Justice Gorsuch, in his majority opinion, says that's not proper, that all claims must be addressed in the final written decision. Now, interestingly, the SAS decision does not specifically discuss how to handle multiple grounds. So you could have, and many petitions do have multiple grounds asserted in the petition. There is discussion in the decision regarding whether or not the petitioner's petition should control the scope of the review, and the Supreme Court said yes, that the petitioner and the petition define the scope of the review. Next slide. So the way the board has implemented this decision and some of the dicta from the Supreme Court is they have decided that they will issue institution decisions as what the board calls all or nothing, which means that the board will institute a trial on all claims and on all grounds, or the board will deny institution entirely. So it's an all or nothing type situation, even though the Supreme Court did not specifically address the grounds issue. The board has determined that, at least for the time being, they will institute on all claims and all grounds. And the practice the board has historically had of partial institution will be something that they will not be pursuing in the future, at least based upon the current board directions coming from the chief APJ, David Reschke. And so what the effect of this means is that for purposes of institution, the board needs only to address a single claim and a single ground. So again, my example of 10 claims, 5 grounds. If the board determines that one claim is likely to be unpatentable, the board need only address that one claim and in that one ground to determine that they should institute the case institute trial on the IPR, and does not have to address the remaining 9 claims or the other grounds that have been challenged and asserted. Now, people have asked the board, does that mean we're going to get these very short single claim decisions from the panels? And the answer is, it depends. The PTAB has said that whether or not the panel for the case provides additional guidance will be up to that particular panel. If they want to address additional claims, if they want to address additional grounds, they're free to do so. And historically, we have seen the panels address in much detail many of the claims, all of the claims, usually in most of the grounds, at least in the sense of whether or not they're redundant or not. So we're waiting to see some of the first decisions that come out post SAS, but the expectation is we're going to see shorter institution decisions because the board simply has to find one claim and one ground likely to be unpatentable to institute the case. Next slide, please. So what have we seen regarding how the board is handling cases that have either are on their way, have been filed, or have been appealed? So I've tried to break down here on this slide the different stages of decisions or of cases and what we've seen the board is doing. And we'll probably have some more input from both Todd and Erica regarding the cases they've been handling. But from what we've seen is for pre-institution cases, the board has said they're going to implement the all or nothing policy. So probably no real ability to make any changes at this point. We have had clients wonder whether or not they can amend a petition that's pending and to maybe limit some of the claims or some of the grounds that they initially put in their case. That's going to be difficult to do, but if the case is early and there's been no preliminary response, it's certainly something you could ask the panel for permission or authorization to make some amendments to the petition. But our general sense is that's going to be unlikely to be successful. That's certainly something to consider. The cases that are more interesting are the post-institutional pre-oral hearing cases. A lot of cases are in that window, that 1 year window between institution and well, it's about 9-month window between institution and oral hearing. In those cases, the board has been issuing reinstitution decisions in the all or nothing framework. And basically, if the cases were partially instituted before, they're going to be fully instituted now. The board has indicated that if there are a lot of grounds that were initially found to be redundant and a lot of claims that initially were found not to be instituted, the panel could now deny institution entirely. So you're not guaranteed that a case that's previously instituted will be reinstituted. And there have been a couple of cases we've seen where the panel has queried whether or not they should simply just deny the entire proceeding, even though they initially instituted the case. And the board can consider its judicial efficiency and economies in deciding whether or not to proceed with a case that was initially fairly simple, maybe a few claims and a couple of grounds, to now a case with many, many claims and many, many grounds. The board may decide not to handle it at all. Then we have the third category of cases, which is post-oral hearing, pre-final written decision. In those cases, the board has indicated they would like to not have to go back and redo anything, but it's up to the parties to try to figure out how to proceed. If one of the parties wants to go back and have additional briefing, potentially additional discovery, potentially additional evidence on a case that is now going to be fully instituted, the board has indicated a willingness to allow some additional briefing and evidence on newly instituted grounds. The board has also indicated that because they have the 1 year deadline from institution to a final written decision, they're willing to extend that deadline by 6 months, the statutory limit, by finding that the SAS, the SAS decision has constituted good cause to extend the deadline. So we are seeing a number of cases where the parties are going back, asking for additional briefing, some additional evidence to address new claims and new grounds, and the board is not happy about that, but they're recognizing that SAS requires it. And then we have the fourth category is post-final written decision and pre-appeal. We have cases in that category as well, and that's a similar situation where the board is asking the parties if they need additional briefing. If one party needs additional briefing, they're hoping parties will agree that neither party does. But in the cases where additional briefing is requested, the board is willing to remand the case back or to send the case back to an earlier stage to allow some additional briefing and additional evidence. Finally, on Federal Circuit appeals, we were expecting to see a lot of remands based upon SAS. We haven't seen a flood of those. We have seen upon a motion a remand based upon SAS. So it seems that if you're in the situation where you're in an appeal and you want a remand based on SAS, you can certainly ask for it, and the Federal Circuit seems receptive to that. Of course, it'll depend upon the stage of the case and all the other factors for the discretionary remand here. But it seems like if a party is going to be arguing that a partial institution case should go back down to be fully instituted, the Federal Circuit is going to be receptive to that. Next slide. And finally, what does all this mean as far as our strategies going forward? Well, we're expecting to see institution rates probably go up, again, because the board doesn't have to look at every claim and every ground. We're expecting to see shorter decisions, and it's easier to get probably instituted with shorter decisions, addressing only a few claims and a few grounds. But we may see petition filings falling off. Petitioners may be more reluctant now to file petitions, given that every claim and every ground is going to be discussed, and potentially it may fail and create an estoppel. We might see more cases, more institution decisions denying the institution entirely because the board just says this is now too complicated, too many claims, too many grounds. We're also expecting to see that the kill rates are probably fall to some extent because now a lot of the claims that initially would have been kicked out at the institution stage are now going to end up at the final written decision, and those claims will presumably be found to be not unpatentable. So what do the patent owners and petitioners do? Well, for petitioners, certainly the focus now is to really limit the attack on your best claims and your best grounds. You don't have the fallback of having claims tossed out at the institution stage based upon redundancy or failure to meet your prima facie case. So we're expecting petitioners will focus their petitions on fewer claims, fewer grounds, and be more careful about the estoppel effects for too many claims and too many grounds. Patent owners, for pre-institution decision, we're expecting that we'll be focusing more on either discretionary denial, trying to get the board to deny the entire petition based upon the complexity of the case, or if there are a few claims that look like they're going to get instituted, then file a very limited preliminary response and focus your major defense in your response post institution. And the idea, of course, is to have at least some claims at the end of the day survive the trial, what we call triage, so that in your patent owner response, that's the first time you present your primary technical defenses to the claim attacks. You focus on the claims you believe have the best chance of being saved. And we are expecting trials to be more complicated now that all claims and all grounds are in. So I think that's likely to happen. I think that's my last slide. I think, Erica, it's up to you.
Great, thanks, Brent. This is Richard from IAM. Unfortunately, we had a few technical gremlins at the start, but I'm well and truly back. So Brent, thank you very much. And it is time now to hand over to Erica from Finnegan, who's going to be looking at the PTO's recently announced proposed rule change to ditch BRI in favor of the Phillips standard. So Erica, please take it away.
Great, thanks, Richard. And hello, everyone. Thanks for joining us today. As Richard said, I'm going to talk about the new proposed rulemaking that the PTO issued on May 8th. So it was a very exciting couple of weeks for parties and practitioners at the board. We had the oil states and SAS decisions on April 24th, which, as Brent just talked about, were very big changes, particularly the SAS decision. And then later that same week, we had written guidance from the board about how to implement the decision. The following week, we had more guidance from the PTAB in the form of a webinar that Chief Judge Rushke held for practitioners, a chat with the chief, as he calls it. And then just a week later, we had this new notice of proposed rulemaking announcing that the PTO is proposing to replace the claim construction standard in PTAB trials. So it was a very exciting series of weeks and big changes afoot. And this, the timing of this was particularly notable. It was right on the heels of those cases. The PTO is moving forward quickly to implement changes in all a variety of areas. So this proposed change to the claim construction standard, I think we all know that under the rules made by the Patent Office when the AIA was implemented, IPRs and PGRs, NCBMs have moved forward with the broadest reasonable interpretation claim construction standard. The justification was that that is useful in a forum where supposedly patent owners could amend their claims. We've all seen how that turned out. Amendments are very difficult, and Todd talked about that earlier, very limited so far in the PTAB, and there was increasing pressure from many different parties, stakeholders on the Patent Office to align the claim construction standard at the board with the claim construction standard being applied in district court and in the ITC, which is the claim construction under the Phillips framework. This proposal will do just that. It will replace the current claim construction standard of BRI and with the standard used by federal courts following Phillips. The rule is a proposed one at this point, although it sounds like many expect it to be implemented one way or another. What we may see is not necessarily a reaction to reject this proposed rule, but maybe more some fine-tuning within the implementation as the public comments are received. A notice of proposed rulemaking process is a formal rulemaking process that's laid out in the Administrative Procedures Act, and so the board and the PTO have requested public comments that are due 60 days after the rulemaking, so in July, and then the office will consider those comments. It's possible they could decide not to make this change. Common wisdom is that they will, but what they may change, as I said, is some of the implementation details, and we'll go into some of those areas where the implementation needs to be made. I'm just going to pause there. It sounds like my audio may be acting up. Does one of the other speakers still hear me?
I still hear you fine, Erica, so I think you're okay.
Okay, thank you, Richard. Sorry, just making sure I'm not just here talking to myself in my office. Okay, great. So let's go to the next slide, and I'll talk you through some of the specifics of the proposed rule and how it will be implemented. Maybe see if I can get the slide changed to match my remarks. Otherwise, I'll just soldier on with this slide. Oh, there we go. Thank you. So the proposed change to the claim construction standard, the Phillips framework is familiar to anyone who's been in district court infringement litigation or validity litigation in the ITC, where the framework for construing claims has several steps. And those are similar in some ways to the broadest reasonable interpretation standard. And many wonder really what the substantive difference is between the Phillips construction and the broadest reasonable interpretation, and often those end up being the same, or there's very little daylight between the two. So that's one common reason to make this change or to support this change, is that it substantively won't change much, but there are actually some pretty far-reaching impacts that we'll get into. But so the framework that would be applied under Phillips begins with the claim language. That's true under BRI as well, that claim language is paramount in the claim construction exercise. The claim language is given the ordinary meaning to one skilled in the art at the time of filing, and then the specification is used to support that. The Phillips case calls it the single best guide to understanding disputed terms, and the specification, of course, is also important in the BRI interpretation. The broadest reasonable interpretation is in view of, consistent with the specification. So those two are the same or very similar in both standards. The difference comes in these last 2 points. The prosecution history is considered in the Phillips framework. That's usually cited as one big, quote unquote, big distinction between the two, although rarely is it completely ignored, even if you're looking at a BRI standard. But that can help particularly to see where there might have been narrowing, where the applicant might have disclaimed certain subject matter during prosecution. That's important to determine the claim scope. And then extrinsic evidence, all agree, is not as reliable as the intrinsic evidence, the actual claim, specification, and prosecution history. That's all the intrinsic evidence, intrinsic to the file, to the patent. But extrinsic evidence may be useful. While that's slightly different than the broadest reasonable interpretation when you just look at the specification, in practice, in IPRs, experts are routinely used extrinsic evidence such as expert testimony. And so that is something that is put in during IPRs and sometimes considered. Less often we see dictionaries or other types of extrinsic evidence trying to show the meaning of a term. But that's not completely different than what we're already seeing at the board. But in any event, that's the framework. The proposed rule then goes into a bit more detail on the prosecution history, and I think there's one of these that's very important for folks to keep an eye on, and that is the prosecution history includes, as we would expect, the original examination, the re-exam or reissue of the patent, any prior PTAB proceedings, IPRs or others involving the patent. Also specifically spelled out in the notice of rulemaking is the arguments made on appeal. I think that's part of original examination, but they use that as a separate point. So really, when we're looking at the claim construction, looking at all of these different places where something could have changed or impacted the claim meaning. But the last point, examination of a related application where relevant, that's the one that I think is important to bear in mind. That's an argument that we see sometimes in cases where an IPR may be part of a larger batch. It's frequently the case, as they're so closely related to litigation, that there are multiple patents involved in a litigation, and so there are multiple IPRs, often in the same family. And so when we are thinking about how to construe the claims using this Phillips framework, we need to bear in mind that it can reach beyond simply the history of the individual patent to family members and other patents that are related if relevant. All kind of nice squishy words that give lots of room for argument and not as much certainty perhaps as we'd like. But that's the framework that would be applied. Again, the same framework that would be applied in the district court or ITC. This kind of goes to, I think, one of the goals that Director Iancu has stated over and over again, which is consistency, predictability, this making the claims mean the same thing at the board and at the district court. If I could have the next slide, we'll talk about some of the finer details in the rulemaking. So here are some of the points that are made in the text of the rulemaking. While the proposed rule is very short, the rulemaking is about 25 pages, and the board went into a lot of detail on what it considered and some of the judgments that it made. And this is where I think we will see some questions, some pushback, some comments from practitioners and parties as they think through these finer details. One of the points that the PTAB makes in the rulemaking is that under the Phillips, consistent with the Phillips standard, the presumption of validity would attach when construing claims. So we'd be construing claims to preserve their validity if there is an ambiguity after trying the other tools, that framework we just talked about. So that's a bit controversial. That's something that hasn't been at the PTO. It's not an original examination. The claims are not read to automatically preserve patentability. And so this is a slight change, but the PTAB in the PTO in the rulemaking takes pains to point out that this is only used when an ambiguity remains after all the other tools are used. It seems they're trying to downplay this part of the change, that they don't expect it to be a tool that is used very often. But still, that is, I think, a significant change to some. The current rulemaking says that this will apply. The Phillips standard would also apply to amended claims or proposed amended claims, substitute claims during a trial. And that's a bit controversial as far as, does that mean there's even less of a likelihood or less of a need to amend claims, and how will that impact the amendment practice before the board? One other sort of open question is, along those same lines, these rules would apply to an IPR, but they chose, the Patent Office chose not to extend this claim construction change to other proceedings, including re-examinations. As Todd talked about at the beginning, re-exams have a robust amendment process, and the broadest reasonable interpretation is used there, similar to original examination. So how does that work where the statute specifically allows for the consolidation of an IPR and a re-exam? But then would we be proceeding with this consolidated case in different claim constructions, and how would that work? That's one of the sort of tricky areas that needs to be thought through. And similarly, how would those impact the ongoing examination of continuation applications? So when you have a patent in an IPR that's part of a larger family, there's still a case pending on original examination. Is the claim construction from the IPR going to bind that later application, even though there's technically a different standard at the office in original examination? So this is going to create some tension in sort of these cases where it's not just a single patent in its first chance at challenge, but in these much more common, more complex situations where you have families of patents, you have multiple patents involved in a litigation and multiple proceedings involving the same patent. If I could have the next slide, please. So a couple more points. The language we quoted earlier says that this switch to Phillips would apply to unexpired patents. That's not really remarkable. Expired patents already receive the Phillips standard because they're not, at least the reasoning given was that they're not eligible for amendment, and so they don't need the BRI. Now that distinction goes away, and unexpired and expired patents will have this same Phillips standard. And then one of the perhaps most controversial things in the proposed rulemaking is the timing of it. It says that it would apply to all pending proceedings before the PTAB. So the day they make this rule, they issue the final rule, it will affect anything that's pending, whether you've already filed a petition and you're waiting for an institution decision, whether you're halfway through your trial, whether you're after argument. Suddenly, this new claim construction standard, the Phillips standard instead of BRI, will apply. And again, kind of goes back to my earlier point. A lot of folks look at this and say, well, but really, is there, point out a case where there's actually a substantive difference. It's really, they're pretty much the same thing. But if you think about the strict requirements in an IPR of briefing, of proving your case, of meeting the burden of proof, when you can do it, it's very limited in time when a petitioner has to put their entire case in their petition. And if there's not support for something there that they want to raise later, they're not allowed. And so with a claim construction shift, you can see where a petitioner might be caught unawares mid-trial. And likewise, a patent owner sort of asked to fight against one claim construction standard and then another. Even if at the end of the day, the substance is very similar or the same, the procedure, the due process of the briefing, and we're preserving arguments and making arguments, is so rigid in an IPR that it will be difficult. Whether there will be additional briefing, whether there will be additional evidence, these are big questions that I expect we'll see a lot of ideas about in the comments to the notice of proposed rulemaking. And then one final point, if I can have the next slide, the notice of proposed rulemaking also made this other point. It's related to claim construction, so I guess it makes sense here. It's a little bit unclear what they mean by it. But so the notice says that the PTO would also amend its rules to add specifically that the office will consider prior claim construction determinations in a civil action and ITC proceeding. So it doesn't say that they will be bound by it, of course, right? It says they will consider it. That, in my experience, is what they do already. If you have a district court claim construction and you file it as an exhibit or part of an IPR, the board will often take note of it, think about it, explain why it doesn't apply, explain why they come up with something different. So they're already doing this, and I'm not sure exactly what the board is trying to add by making this explicit, but clearly there's something behind it. And so that'll be interesting to see how that plays out. The statements about the term, the way that this is written, talks about the claim construction determinations. So that sounds like a Markman order or a claim construction order from a court. I think it's also interesting to note that there is already a provision to provide patent owner statements about claim scope to the board in the statute in section 301, where anyone can file a statement of the patent owner. Often it can be something they've said in the related district court or ITC action. And so presumably, since it's in the statute that you can file it, the office will consider that, what's filed under 301, but they're not including that in this new proposed amendment about considering prior claim construction determination. This is an area that I think is particularly fuzzy in the proposed rule, and expect to see some comments and some proposed changes and questions to flesh out this this statement a little bit more to figure out really what it means, and likely it will be seeing how individual panels implement it before we really understand the impact of this part of the proposed rule. With that, I will wrap it up and return it to Richard, I think, for the question and discussion portion.
Great, thank you, Erica, and thank you, Brent and Todd. So we have about 20 minutes for Q&A, and plenty of time to discuss plenty of meaty topics. And I would encourage all listeners, please, to submit any questions they have via the GoToWebinar platform. And in fact, we just had a quick question for Brent related to some of the comments that you made, Brent, and in fact, a case that you referred to that was remanded for SAS by the CAFC, and I wondered which case that was. That was the question from the audience.
Sure. It's a case called Ulthera, spelled U-L-T-H-E-R-A, versus Dermafocus. The case number is 2018-1542, and the decision just came out, I think it was May 25th. Based upon motions that have been filed post SAS. So Richard, you and I can discuss offline. If you want me to send that case to you, we can route it, or folks can just pull it up. But that's the one I was referring to.
Okay, great, excellent. Thank you very much, Brent. Todd, I wanted to come back to you because you set the scene for us at the start, the sort of the PTAB landscape. And I wondered, given the changes that we've seen with SAS, given what we've seen with the rule change or proposed rule change around the claim construction standard, what your thoughts were when you take these changes, and how they affect petitioners and patent owners, and particularly who do you think they sort of benefit most, petitioners or patent owners?
I think it's a close call, but overall I would say that they collectively benefit petitioners more, and let me explain why. The majority of patents in IPR are also involved in concurrent litigation, and with district court litigation, typically a stay would benefit the petitioner, or in IPR, or the defendant in the litigation. And how do you get those stays? Well, I think SAS or SAS enables what I call identity of claims. So if I have been sued on claims A through C, then I can also file a petition before the PTAB challenging claims A through C. And with SAS, if I can at least have one claim meet the reasonable likelihood to prevail standard, then I'll have trial on all 3 of those claims, which will be the same claims that are in the district court litigation. So I have identity there. Also, I now can go to the district court judge and say, hey, look, the PTAB is going to apply the same claim interpretation standard, Your Honor, that you're going to apply. So you're going to get the benefit of seeing what they believe or how those claims should be interpreted. So you have the identity of claim interpretation standard working to your benefit as well if the proposed rules package is implemented. So with those 2 things, I think you see increased stays, which are overall beneficial to the petitioner. However, looking at the rules package for claim interpretation in isolation, I think there's an argument that theoretically that benefits patent owners because now they clearly get the benefit of looking at the original file history when construing claims. But as Erica explained, their argument that there's really no practical difference between Phillips and BRI. And if you even go back to Microsoft v. ProxyCon, pre the proposed rules package, there was already guidance from the Federal Circuit that the original prosecution history should be considered during claim interpretation. So I'm not sure how much the proposed change in the claim interpretation standard applied at the USPTO really moves the needle for patent owners. So overall, again, I think these packages and the SAS case benefit petitioners.
Brent, Erica, would you agree?
Yeah, so this is Brent, Richard. I agree with Todd's comments. Certainly with respect to oil states, there were a lot of people that were waiting on the sidelines really praying for a reversal. That would have greatly benefited patent owners, but that didn't happen. So oil states is an unequivocal victory for petitioners. I think with regards to everything that Todd said, I agree with for benefit of petitioners. I would point out, and I think Todd indicated that there's kind of a balance here. And I think the one thing that helps patent owners in the SAS decision is this notion of having all claims in the case to be decided up or down. Traditionally, before SAS, a claim or a challenge that was weak would not have been instituted, and that would have probably not been stopped based upon current case law. Claims and challenges that do not get instituted in the trial do not implicate estoppel. So that those claims and challenges would have potentially been available for the petitioner, to assert in litigation. Now those claims and challenges are going to be part of the trial. They're going to be instituted, and so if the board finds that those claims are patent or not unpatentable, then there should be estoppel on those claims, and those claims will be saved for the patent owner for purposes of at least like an IPR's printed publications, and that would be one benefit. I think the enhanced estoppel that we're going to see because of SAS will probably benefit patent owners. Erica, what do you think?
Yeah, I agree. I think there's something for everyone in these, and I agree with both of your comments on that.
It's interesting though, Erica, with some of the comments that you made around BRI. You pointed out there are a lot of questions that remain unresolved here, and we'll probably get some answers once the consultation period has come to an end. But I wondered, in the meantime, how do you advise clients on the sort of shifting landscape here at the PTAB?
So I think that there are a lot of strategic considerations and that keep changing. As I said, the different rule packages coming out, or the guidance from the PTAB coming out so quickly after the Supreme Court decision, then this new proposed rule change. And then if you listen to Director Iancu's recent remarks, speeches, and testimony at Congress, lots more changes to come in the PTAB. This is clearly an area of focus for him. And so I think one of the best pieces of advice that I try and give all of my clients is there's a lot of uncertainty right now, and we need to be flexible and we need to be nimble in our strategies. And so we've talked already about a lot of specific strategies for how to getting those patents that have a robust record at the PTO, like Todd talked about. We talked about the strategies at various stages in a PTAB trial and implementing the SAS decision. But sort of a step above those specific details is helping companies, patent owners and challengers, to adapt and adjust to a very uncertain landscape right now, where there are a lot of shifts happening. Even during these fairly compact trials, the rules are changing mid-trial for a lot of parties. We're not sure yet. If you're writing a petition today, are you writing a petition under the BRI? Yes. Are you also talking about Phillips? Perhaps, because it's possible the rule will change in the fall. So there needs to be some flexibility and a comfort level with. There isn't going to be a bright line 100% guarantee on just about anything. And the board still has wide discretion in a lot of areas. I mean, the Supreme Court said you don't have this discretion, this partial institution discretion in SAS, but there are lots of other areas where the board has wide discretion. And hopefully additional guidance. The office has talked about more informative and precedential decisions from the board will help to get more certainty. I know that's what the office is working towards, but it is not. It is a very uncertain time right now in the PTAB. And so I think it's important to kind of prepare for that and not lose sight of kind of the big picture just because the details are shifting.
Yeah, absolutely. And Erica, we're just staying with you because we have a question from the audience asking, what is the burden of proof at the PTAB?
So the burden of proof at the PTAB is to prove the petitioner has the burden to prove a proposition of unpatentability by a preponderance of the evidence, which is a different standard than a challenger faces in a district court, where invalidity must be proven by clear and convincing evidence. The PTO cannot change the burden of proof on its own. That's something that's in the statute, and so they have to make their regulations, of course, consistent with the statute. They can change the claim construction standard because that is something that Congress didn't set in the statute. They left that, the claim construction standard, to the board to decide, and so they did, and now they're changing it or proposing to change it, and that's within their congressionally granted authority. The burden of proof was not granted to the PTO, was put right in the statute. So there's another point, it's a great question, where there's some tension with the level of proof being different, the standard being the same. The PTO talks about when you're construing claims consistent with Phillips, you construe them to preserve validity, and I think I probably said presumption of validity. Presumption of validity is usually tied to the clear and convincing standard. So here, where the board is talking about construing them to preserve validity, is that something different? Sort of where is that wiggle room, and how to make that consistent? Because the PTO wants to make this rule change, but they can't make the change to the burden of proof, even if they wanted to. So that's kind of another gray area where some clarification would be very helpful, either from the PTO or future cases, or perhaps even Congress at some point.
Great, thank you, Erica. And we have another very interesting question from the audience. Brent, I'm gonna throw this one to you. What is the 20,000 foot view on the impact of IP value going forward in light of the oil states decision and pending changes to the PTAB? And how would you assess that?
That is the big question right now, Richard, and I think your audience member puts his or her finger on the pulse of what's happening in public policy. Certainly, the perception and what Director Iancu is focused on, or at least considering, is the perception of the value of IP has been diminished. We're seeing essentially half, and I guess depending on how you calculate your stats, but roughly half to 45% of the patents that get challenged, the claims that get challenged, get killed. And that, whether or not that's good or bad depends upon your perspective, but from the patent office perspective, that rate is considered to be too high, and that it is depressing the value of innovation, the value of patents. We're seeing a lot of stats about how our patent office is deemed no longer to be the best in the world. We're seeing investors moving away from investing in IP or believing that that investment in IP is not as worthwhile. So I think currently the pendulum has swung pretty far over, and this is largely, I think, due to the concerns about frivolous litigation and troll litigation, the concern that too many frivolous lawsuits or lawsuits by NPEs have depressed business. Well, the pendulum has now swung to try to rid the system of those kinds of lawsuits, but maybe it's swung too far, where now many patents are being killed. And I think Director Yonke is very focused on trying to bring that pendulum back. And so you'll see, I think, you see Congress looking at the Stronger Patents Act, which is a very pro-patent legislation that they're proposing. Both House and Senate have bills for the Stronger Patents Act to try to address what they see as the overreach of the AIA or the decline of the value of IP. So I'd say currently, yes, I think we've seen a decline in people interested in investing in IP, but I think that's going to change. I think the country recognizes that our value in our businesses is in innovation, in intellectual property, and we need to just find the right balance. And I think right now, the perception, at least, is that the balance is too far now anti-patent. But I expect that'll change over the next few years.
Sure, thanks, Brent. Todd, I'm just wondering if you, just continuing along that line, do you think that the message around the change in BRI is actually more important than the practical implications that it brings about, the actual change that it brings about the PTAB?
No, I agree. I think that the optics, the intent is to show a change in course at the PTO, where the claim interpretation standard, by changing that to be consistent with Phillips, is showing a need to assist patent owners in maintaining a valid enforceable patent. I think a next good step would be, and this is kind of the theme of my introduction, was if we could also offer patent owners an opportunity to maintain some type of modified claim scope or clarified claim scope with some real practical opportunities to amend, that would also be helpful to patent owners and continue along that theme. I'm quite aware of intervening rights and why often that will provide a reason not to amend or a hesitation to amend with concurrent litigation. But if we go back and look at the old IP re-exam data, you will see that many patent owners were still taking opportunities to amend, even when there was concurrent litigation, to preserve that patent for maybe a later licensing effort or a later opportunity to assert against a second party. So I'm hoping that Iancu will look into the amendment process as well.
Do you agree, Erica? Do you think amendments are next in line?
I think they are likely one of the next in line, yes. We've heard quite a list of topics that the board is in the process of revising. We hear them talking about updating the trial practice guide to give more concrete guidance, giving a new standard operating procedures for things like expansion of panels, amicus briefing, joinder, rehearing. There are a lot of topics that they're looking at. I think the board is making a big effort, and Director Iancu kind of leading it, to really change the narrative around the PTAB and to show activity and proactive efforts to improve the quality of what's being done at the PTAB, the fairness, the predictability, and to kind of fix some of the things that Brent was talking about with the sort of perception of U.S. patents having been sort of declining in recent years. I think one of the things that they are starting to do a good job of is taking a positive approach to their message, and also sort of touting some of the improvements that the board has made in other areas, so sort of peripheral or adjacent areas like the appeals, the ex parte appeals, the appeals from re-exams like Todd was talking about, and appeals from original examination. The board has really overhauled that part of their practice, which is a huge part of the board's practice and really helps to ensure quality patents in the first place. If you can get on your original examination and appeal, if you can get a good, quick decision that gives you a strong patent, it will set you up better for future, make that patent more valuable. In the last, I think, 5 years, the Patent Office has attacked its backlog, and the huge number of cases, the appeals used to take 3 years at least. It was almost prohibitively long for applicants to consider pursuing an appeal. And now, at least the most recent numbers I've seen, the pendency is down to 14.3 months. That's just an amazing difference in that time frame, and it's been a real concerted effort by a lot of the PTAB and the Patent Office. And I think improvements like that are becoming more a part of the overall narrative when we talk about sort of the value of patents and how to get patents that are valuable, can be monetized, can be enforced, that will be held valid. I think that's an important part of the storyline that the PTO is trying to get more of the word out. So hopefully we'll see other improvements like that to continue across the board.
Great, thanks, Erica. And just a final question for the three of you. Todd, perhaps we can start with you. A lot of the PTO has done a very good job at putting out plenty of data to show how patent owners and petitioners fare at the PTAB. And of course, for several years, certainly the early years, the numbers didn't look good for patent owners. And we all know some of the sort of names that the PTAB picked up as a result of those. The numbers have dropped certainly in terms of invalidation rates over the last couple of years. So I wondered, Todd, do you think the numbers will start to look a little better for patent owners in light of these changes?
I think that we've kind of reached a steady state where we're seeing about a 65% success rate at the institution stage. And we are seeing other claims sneak out and maintaining their patentability at the final written decision. And I don't see a huge change here. The thing that I was surprised about was the acknowledgement from the PTO that because of SAS, that there might be some cases where they would have instituted before, but they wouldn't institute today because there would be effectively too many. The case would become too complex to handle. And to me, that was hard to reconcile, that if you've shown a reasonable likelihood to prevail, I wasn't sure that there was discretion to not institute based on complexity. So I'm not sure how that will impact the overall numbers, but it's my sense that the overall stats will stay roughly the same.
Do you agree, Brett?
Yeah, so I think everything Todd said is correct. I think if you break it down between institution and final written decision, I think we will see institution rates go up, only because now the burden is fairly low. A single claim and on a single ground is enough to institute on everything. So I think the expectation is that we're going to see higher rates potentially, but at the end of the day, when you get to the final written decision, and you have to address all claims, then you're going to see more claims escape that final written decision as being found not unpatentable. So on balance, we may see roughly the same kill rate if you combine both of those factors into what's the likelihood my claim is going to survive an IPR. I do think, though, that there is pressure on the board and on the PTAB to lower the overall kill rate. I think you compare it to opposition proceedings in Europe, you see that the kill rates are quite a bit lower, even though there's a lot more amending going on in Europe. So I do think that the perception that the board is a death squad is diminishing, but I don't think we're there yet. And so I don't know what the correct, what the true kill rate ought to be, but I think where we're at is, numbers I've seen are about 55% survival rate. Todd's was a little higher than, I guess, depends on what stats you're looking at. But I think you've got to get into the 40s, high 30s, low 40s before people begin to feel comfortable that the board isn't being overzealous in killing patents.
Would you agree, Erica, that the numbers will start to look a bit better for patent owners?
Yeah, I think I would agree, although I will not join in the use of the phrase death squad or kill rate, because I think that's one of the things the PTO is trying hard to get away from, is that kind of, as you said, that perception, but also that sort of view that it's how many claims are killed versus how many are surviving or being found patentable. And I do think Brent's right on that there will be more institutions, but at the end of the day, more claims will survive because they probably would not have been instituted if there were a partial institution power. So I think that's exactly right what Brent said about that. I think there is likely that we will see very little change in the number of petitions being filed. People will be a little more thoughtful, but I don't expect much of a change. People sort of running from the patent office or choosing not to file their petitions based on the changes we've seen most recently.
Sorry, we have one last question actually from the audience, which I think is very worth asking. And it is, from a practical standpoint, should parties address the BRI standard and also address the Phillips standard in the alternative in view of a likely rule change, or wait for the rule change and assume additional briefing will be allowed to address the Phillips standard? Would anyone like to take that?
Todd speaking. This is Todd speaking. Because I've always thought that the practical differences between BRI and Phillips are slim to none. Typically, we've asserted it means the same thing. And I think in most cases, that's probably the most likely outcome, is that this is what the claim term means, whether you apply BRI or Phillips. But I guess this does give you an opportunity to hedge, to submit that it means one thing, but based on what the PTO ends up using as interpretation standard, it can mean something else. But again, for all intents and purposes, it's the same outcome, same meaning.
Richard, this is Brent. Oh, sorry, Erica, go ahead.
No, you go ahead, Brent, thanks.
Okay, just real quickly, I agree with Todd. What we've been doing is dropping a footnote and recognizing the potential change in standard, and then saying that we believe that the construction will be the same under either, typically because we're not advocating anything more than what we think the spec is suggesting and what the ordinary meaning is. So we are trying to address both, but we're not typically doing a substantive second analysis.
So this is Erica, and I agree. I think I don't expect to see petitions that have a full workup of an analysis for each of the two claim construction standards. I think some of the reasons that Todd and Brent have given are true in a lot of cases. From a practical standpoint, there's not room usually in a petition to talk about alternative standards and claim construction positions. One thing I think that would be something to watch for, though, is because often what petitioners have done is, rather than maybe saying it's the same under either standard and here's the construction, petitioners are also able to say it's plain and ordinary meaning and it's at least broad enough to cover this art without having to set forth a specific construction. That's something we've seen a lot of petitioners do. And so I think if that's going to continue, I think that certainly would weigh against going through a bunch of different claim construction standards. I think one thing that maybe come into play a little bit more is if we are going to put the construction standards together so that the claims mean, as the proposed rulemaking says, claims mean the same thing in a district court for both validity and infringement. Now they're going to mean the same thing at the patent office. I think we'll see patent owners with their infringement contentions maybe being held a little bit more to the positions they're taking in the district court on infringement and what their claims mean, what they cover in a current product. So there may be an opportunity there for petitioners to use that a little bit more, because we're going to be, if this rule goes into effect, we're going to be aligning the cases even more closely. And so patent owners will have perhaps be a little bit more tied to positions that they're taking with respect to infringement allegations, even in, beyond the specific claim scope statements that could come in under Section 301.
Great, thank you all. So that is all that we have time for today. So thank you to the audience for your questions and for your participation. And just to let you know, a recording will be made available for all attendees in the next few days. So that just leaves me to thank Todd, Brent, and Erica for their participation, and for all of you listening. Thanks very much. Goodbye.